Hello, so welcome back to English Law. So I've been looking at a duty of care and so on, the Caparo test. Now I'm going to look at a different possible test, and that is assumption of responsibility. So sometimes this test is used, and that's whether someone has voluntarily assumed responsibility, in the case that the defendant has assumed it for the claimant. Burgess and Lejean 2017, is an important case about that one. So this test is a bit unclear, and there's a certain circularity to it. And it's especially used in cases where there's claimed to be liability for misstatement or for economic loss and omissions. Remember that generally speaking, pure economic loss is irrecoverable in tort. So what is the situation presently? And that is that if there's a duty of care, that doesn't depend on the application of the Caparo test to the facts. It is instead dependent on the application of principles which are laid down under the law of negligence. This is what Lord Reed had to say about it in Robinson. Caparo thus achieves a balance between legal certainty and justice. In the ordinary run of cases, consider what has been decided previously and follow the precedents. In cases where the question whether a duty of care arises has not previously been decided, the courts will consider the closest analogies in existing law, with a view to maintain the coherence of the law and the avoidance of inappropriate distinctions. They will also weigh up the reasons for and against imposing liability, in order to decide whether the existence of a duty of care would be just and reasonable. In the present case, however, the court is not required to consider an extension of the law of negligence. All that is required is the application to particular circumstances of the established principles governing liability for personal injuries. That's the end of the quotation. So let me sum up the duty concept. The duty concept serves two different functions. Is the duty there at an abstract level? There's a notional duty in law. For instance, does the motorist have a duty of care to other road users, or do barristers owe a duty of care to those who are relying on them, as in have hired them? So is the claimant within the ambit of the duty of care? For instance, a road user is owed a duty of care by a specific driver. Well, in Borehill and Young 1943, the claimant heard but didn't see the crash occasioned by the defendant's motorbike negligence. The claimant then saw what happened after the accident and then sustained nervous shock because he was so traumatized. The woman didn't prove the existence of any duty of care to prevent nervous shock, so she was considered to be an unforeseeable victim. And remember, foreseeability is vital in proving negligence. And so this was too far removed from the scene of accident to be considered a reasonably foreseeable victim. So the claimant failed. The tests that we use here are when the law is unclear. So there are concepts that judges will cite when they are adjudicating whether or not a duty of care needs to be recognised in a novel situation. The most complicated and developing instances of the law of duty are there when there's special duty problems and negligence. So let's look at the duties of a barrister or solicitor. So these legal professionals have a duty of care to their clients. All professionals have a duty of care to their clients. But it was not until recently thought that the barristers owed a duty in respect of work was connected with presenting their case in court. So in the Caparo test, it would be said that yes, there's foresight, there's proximity, but it was not fair, just, or reasonable for them to say there's liability. In Arthur J.S. Hall and Simons 2002, it was an appellate court case where eventually the House of Lords is found that in the current situation there are no policy reasons which would warrant this immunity, and therefore it's done away with. In three separate cases, clients have brought cases against solicitors where they said that the solicitors had been neglectful of their duty. The judge at first instance said there's no claim of negligence here because the defendants had to depend upon the advocate's immunity, as was found at the House of Lords in Rondell and Worsley, 1969. And this would set out the policy reasons for advocates having immunity from liability in case of people saying there was negligent behaviour. In a court case, the Court of Appeal found that the claims should not have been rejected, and the solicitors appealed against this decision. So a seven-member constitution of the House of Lords dismissed the appeals and found that because of the changes in society and the law which had occurred since the decision in Rondell and Worsley, the propriety of saying there was immunity was no longer applicable and valid. Therefore, the advantages which arose to the public interest from advocates' immunity and negligence had to be weighed against the ordinary right of a client to be compensated for a legal wrong, and there was no longer a sufficient public interest to say that this immunity was sustainable. So their lordships were all agreed that the decision to do away with the civil immunity, to do with immunity in civil proceedings, and by a majority to do away within criminal proceedings as well. So what are the duties of lawyers? Well, the situation where a duty is owed and the extent of this duty was something which the House of Lords had to mull over in Moy against Petman Smith, a firm, in 2005. The claimant in the case had been operated on, and this went awry. So negligence was conceded on behalf of the health authority. So former solicitors and a barrister, they acted for him when he launched a negligence action against the said health authority. The health authority said they pay £150,000 and a waiver of costs against the claimant. But the barrister said, no, you should shun that advice. So going along with the barrister's advice, the client turned it down. Anyway, so the case then carried on. The health authorities offer went down to £120,000 and the normal costs. And anyway, the claimant was then advised by the barrister to say yes to this offer because that's probably the best they were going to get out of the health authority. So an action for negligence was moved against the barrister. The trial judge said that the barrister had not been negligent in the advice that she'd given her client. Now, the Court of Appeal said that her assessment of the likelihood of success in the case was not negligent, but the barrister had neglected her duty in not telling the client enough advice so that the client could make a properly informed decision. Remember, an uninformed choice is no choice at all. And armed with that information, the person might have made a different decision about whether or not to accept the settlement. The barrister's appeal to the House of Lords was permitted because the House of Lords had regard to the whole set of facts and the advice proffered by the barrister, and this was thought to be within what a competent legal professional would say. So a counsel of her level in the profession, and there was a need for advice urgently, and there was time was a factor. It said that her advice to the claimant was not so far below the standard that would be expected of a practitioner at that stage in her career. The Court of Appeal said that the House of Lords said the Court of Appeal had been too hard on her. So then there is Steele against NRAM Limited, 2018. So this went to the Supreme Court. So Miss Steele was a solicitor, and she was acting for someone who was in a commercial case, and she dealt directly with an unrepresented lender, Northern Rock, that bank which had such trouble in 2007. Now, she'd been grossly negligent in what she'd said. She'd assured someone in an email to the lender that of the suggested financial transaction. So they'd relied on her assurances, and the lender had then sustained a major pecuniary loss. So the lender tried to recover the money from the solicitor, but the Supreme Court looked at several cases like Headley Byrne against Heller 1964, and it found it had not been reasonable for the claimant to depend so heavily on those insurances when they could easily have verified this themselves, and that's what they ought to have done. So, and that then they would have found what the truth was. Moreover, it would not be reasonable for Miss Steele to expect them to rely upon what she said. So on those grounds, there was no special relationship and a duty of care did not exist. So they found the favour of the defendant, and indeed there was no liability for the negligent misstatement either. So that's enough for the moment. Toodaloo.